extensive comment letters expressing our views on these issues. But finally, this past April, they finally came up with a proposal for a best interest standard of conduct for broker-dealers and their reps. And then in June, they finalized that rule. Now, key thing here is, since you can never go wrong quoting a philosopher, and particularly Hall of Fame baseball catcher Yogi Berra, remember that, as Yogi said, it ain't over till it's over, which in this case here means that a couple of lawsuits have already been filed challenging Reg Bi, one of them by 7 state attorneys general. The main thrust of these lawsuits is that Reg Bi, the best interest standard contained in Reg Bi, doesn't meet the requirements of the Dodd-Frank law that I previously mentioned. And since a regulator can only do what the lawmakers allow it to do, the rule should be declared invalid. So the bottom line is that the status and future of Reg Bi, which is in place right now, is somewhat up in the air, but these cases are likely not going to be resolved before the June 30th, 2020 effective date for the regulation. So broker-dealers and their reps do need to prepare to comply with the new requirements going forward. So briefly, we're going to be talking, as you see on the slide in front of you. First, we're going to talk, that was just background I gave. We're going to have sort of an extension discussion of the rule meeting and associated rules along with it, a client relations summary form, some other requirements of the rules. Then we're going to talk about, I'm going to talk into a little detail about state activities. Then we're going to go into a pretty extensive discussion of what this all means in the real world for everybody. And then we'll take a few questions, and hopefully that'll help inform your knowledge about this rule, and we can all go about our day. For now, let me turn things over to my colleague, Judy Carsward, who's going to dive into a little bit more detail on the timeline, fill in some details, talk about what some other agencies were up to during these years, and how all of this impacted what the SEC ended up doing. But before I turn it over to Judy, let me say something you're going to hear repeated many times today. The bottom line is that whatever you hear today and take away from this webinar, whatever you may read or be told by me, us, anybody else, you need to always remember that you should follow the instructions, the procedures, the direction that you will get from your broker-dealer. Do what your BD tells you to do. And with that, let me turn it over to Judy.
Great. Thanks, Gary. So as Gary has said, the SEC regulation best interest is final and in place. It has a delayed implementation date. We'll talk about that in just a moment. But while the SEC was busy collecting comments from stakeholders and examining current rules for registered reps and broker-dealers with respect to standard of conduct, the Department of Labor, who has jurisdiction over qualified plans, but not all securities transactions, SEC, all securities transactions, Department of Labor, only over qualified plans, was struggling with writing a proposed regulation to address what they perceived as the gap between a suitable recommendation and what would be clearly subject to a fiduciary standard, and looking for recourse based on any failure to meet a fiduciary duty. The Department of Labor's first proposal was released and subsequently withdrawn. Their second reproposal, try number 2, created havoc. Failure to work with the SEC and or stakeholders resulted in such a poorly written proposed regulation that Congress tried to defund the department's ability to promulgate the rule. Congress tried to pass legislation that would do what the DOL's proposal purported to do. NAFA weighed in with this Steptoe Council in conjunction with the rest of the NAFA staff, with many DOL rule writers, and in hearings at the Department of Labor and in congressional committees, pointing out all of the problems with the Department of Labor's proposed regulation. Eventually, the department issued a final rule. It did reflect many of NAFA's suggested improvements, but it was still unworkable in that it limited access to education and advice. It restricted choices on how consumers would engage professionals. It blurred the lines between education and recommendations, and because of a new exemption called the Best Interest Contract Exemption, or the BIC, it is now infamously known, opened the door to private rights of action, class action, and either further limitation to consumers' abilities to get personalized advice. As you all know, NAFA joined others in a lawsuit, and ultimately the courts vacated that rule in its entirety. For another day and another time, we will talk about what the Department of Labor may need to do to make the SEC rule work within existing ERISA requirements. That is another day. I will tell you that the department, Kate is laughing, that the Department of Labor is promising to align whatever they do in the next few months with regulation best interest. And so we're waiting to see on that. So enter the SEC. The Department of Labor rules is vacated. The SEC now has a pretty good roadmap of what not to do. Already they had agency expertise for writing a regulation requiring regulation and enforcement of securities, including those involved in qualified plans. They did seek stakeholder input, and they watched the marketplace's responses to the Department of Labor's fiduciary rule and had in mind several goals so that they did not make those same mistakes. The rule is very complex. It is very long. Kate Jensen from Steptoe is here to break down this rule so that you can get an understanding. Today's goal is to get an understanding of the rule and what will be required. And as Gary has noted, and we might note once or twice, again, during the course of this presentation, ultimately the specific requirements will come directly from your broker-dealer. So with that, I turn it over to Kate.
Great, thank you, Gary and Judy. Great to be here today. And as Gary noted, the SEC's rule is here to stay. It is final, and pending any unfavorable lawsuit outcome, we should get prepared for what is coming. And today, I'm hoping to just give sort of a very brief 30,000-foot overview of the main components of the rule that will impact NAIFA members, and to be very clear where the obligations under the rule apply to registered reps directly and where the obligations have really been limited to your broker-dealers. That's going to be an important distinction for you all going forward. So at a very high level, there are 4 core elements or buckets inside this SEC rule. The first one, the primary one, the one where most of your interest likely resides, is with the regulation best interest. This is the new standard of conduct regulation. Accompanying regulation best interest is a new Form CRS, which is a client relationship summary. And then 2 other elements that we're not going to spend as much time on here today. These are interpretations largely of current law. One interpreting the current solely incidental exemption for broker-dealers under the Advisors Act. And the second one is actually for investment advisors. And what it attempts to do is to consolidate the federal interpretation of what the fiduciary duty for investment advisors is. So that one's kind of beyond the scope of today's discussion, so that we're going to leave that one there. Compliance dates, again, coming up June 30th, 2020 for Reg Bi and the new Form CRS. And those interpretations that I mentioned, those were effective immediately upon publication. So going into Reg Bi, I think it's important, given the history that Judy laid out for us, to talk about what this doesn't do, right? There was a lot of sort of panic, frankly, when the DOL came out with what was perceived to be a completely unworkable rule. So from that perspective, you know, we have some positive things on the table before us now. So this is not a fiduciary standard. Reg Bi is not intended to raise the conduct of standard for broker-dealers and registered reps to the fiduciary standard of investment advisors. And there's no requirement that advice be conflict-free. So recognizing that broker-dealers and registered reps get paid for the products that they sell, you can still receive variable compensation for those sales. And the SEC specifically I mean, they say over and over again in the preamble to this rule that they really want to maintain that optionality in the marketplace for investors. You don't have to recommend the cheapest option to the client or the option that pays you the least for the sale. There's no new private cause of action, so no contract, no class action right created there. And an important point here that Judy raised, it preserves investment education and general information about investments and your ability to deliver that to clients before you're sitting down with them and asking them to sign a document or buy a specific product. So that was extremely important to NAFA members, and that was something we emphasized a lot in our comment letters to both DOL and the SEC. So that's a great win for us and for the industry. So, Reg BI, this, to be perfectly clear, only applies to broker-dealers and registered representatives. This is not in the investment advisor space at all. They are subject to their own fiduciary rule, completely different bucket. This is designed by the SEC to be an enhancement of the suitability standard. So it is meant to be a stricter standard than suitability. And you'll see as we kind of go through this presentation where they've added in some elements here, such as additional, more consumer-friendly disclosures, conflict of interest, mitigation measures, these types of things. Best interest is not defined. So they determined that there is no laundry list in the universe or checklist of items that you could possibly go through for every single client and come up with capital T, capital B, the best option for a particular individual. So they left this they left this principles-based and behavior-based, which is what we were looking for. So to act in your client's best interest means that you have satisfied the obligations under the regulation. Those obligations are the disclosure obligations, the care obligation to act in your client's best interest, and then on the BD side, they have conflict of interest and compliance obligations. Okay, so launching right into what applies directly to NAFA members. So disclosure obligations, these apply to broker-dealers and to their registered reps directly. So, you know, we envision that the BDs will have a major role in designing these new disclosures. These particular disclosures can be incorporated into existing documentation. So, you know, I anticipate we'll see a lot of that instead of new paper. But here's the big catch on this one. If you, as the registered rep, as you're sitting across the table from your client, realize that whatever the stock disclosure that your broker-dealer has provided really doesn't disclose all of the material facts as they pertain to this particular situation, it is your obligation to supplement that disclosure to make sure that in this, you know, particular conversation, you're disclosing all of the material facts that a reasonable client would want to know. So that's the main takeaway on this one. Look to your broker dealers for a lot of the design and the rollout of these new disclosures, but recognize that you are directly on the hook as a registered representative to satisfy this particular obligation. So what are we talking about disclosing? You have to tell your clients a lot, frankly, which is, you know, this is a heavy disclosure-based regime, and which I think makes sense given the way that the SEC has structured their rule. You know, you have to tell them up front, I'm acting as a broker-dealer or a registered representative. This new best interest standard applies to me, and in this, you know, relationship that we're going to have with you as my client, you do have to disclose material fees and costs. To be clear, this is not a specific dollar amount. So you, Judy, today are going to have to pay me $25. So this can be sort of generalized. You can come up with a range of amounts, a range of percentages based on the types of products that you've recommended to this particular client. So it can't just be as generic as, well, I'm going to get paid, or I'm going to get commissions, maybe. So this is a little bit more detailed than that. This is meant to be the second layer of disclosure, following the form, the client relationship summary, which we're going to talk about next. But here, you know, this is where you would say, okay, as your, you know, as I'm advising you, as I'm recommending these products for a mutual fund, I would typically receive a dollar amount in this range. So think those types of fees and cost disclosures. Again, there's an obligation to supplement here. So if somebody ends up actually buying a product that does not fall within these comp disclosures that you initially disclosed, then you need to supplement that initial disclosure to make sure, just, the goal here is to make sure that it makes sense for the conversation you're having and for the individual with whom you're speaking. And you got to disclose your material conflicts of interest. So we put some of the common examples on the slide here. Those of you who are limited in your sales of only proprietary products, you need to disclose that at this point. Rollovers, which are definitely covered by Reg Bi. So when you're recommending a rollover from an IRA to a different kind of account, those are definitely covered and they need to be disclosed up front. And then again, if you're going to be compensated based on what you're selling, you don't have to get into dollar amounts, but you do need to let your folks know, your clients know. And here's a big one for NAIFA members. This is where the titling restriction ended up. Although, to be clear, this titling restriction in the final rule is much improved, I think, from NAIFA's perspective compared to where the SEC started. So, broker-dealers and registered reps who are not also licensed as investment advisors may not use advisor in their name or title. So, to be clear, you can use the word advisor as a general descriptor in your marketing materials. So I've been advising on these products for 40 years. That's fine, that works, because you're not using that in your name or title. Also, I know a lot of you guys have the NAIFA name and logo on your business card, which is great. NAIFA obviously has advisor in its name. You can use that, that's fine. That's not your name or title. So that's where we ended up on that. We know that this is going to take some adjustment in the marketplace. We certainly don't mean to diminish the impact of this one, but I think that it did work out better than sort of the very broad sweeping prohibition that was in the SEC's proposed rule. Okay, the care obligation. So what this boils down to is you must exercise reasonable diligence, care, and skill to have a reasonable basis to believe that the recommendation is in your client's best interest. And this comes with the things that y'all are already familiar with under the suitability regime. So you have to believe that it's in the best interest of some investors. You have to believe that it's in the best interest of a particular retail customer. And you have to have a reasonable basis to believe that a series of recommendations is not excessive. So this is a familiar structure for all of you, but really what they've done here is they've enhanced this by tying it specifically into this best interest standard. The best interest standard, of course, meaning part of that meaning that you cannot put your own interests ahead of your client's interests. So this is, this is kind of this is the core, this is the crux of this new regime. So we'll kind of go through these next two obligations a little bit quicker because these are the ones that fall specifically on the broker-dealers, not on the registered representatives themselves. So conflict of interest obligation, again, this is a disclosure-based regime as the SEC has designed it. You'll see here that we've underlined, you've got to disclose or eliminate, identify and mitigate, identify and disclose, blah, blah, blah. So they've really clearly bucketed these things out. Disclosure is going to be the first step for a lot of these. When it comes to compensation incentives that might entice a registered representative to put his or her own interests ahead of his or her client's interests, that's where the mitigation measures come in. And we'll talk a little bit, we'll give some examples, concrete examples on the next slide. Notable for NAIFA members though, you have to eliminate at this point sales contests, quotas, bonuses, non-cash compensation based on sales of particular products within a certain time frame. So no more annual contests for, quotas, trips, these types of things. So that's going to be a change that you'll see coming from your broker-dealers for sure. Conflict mitigation, right? This sounds like terminology that lawyers throw around which is fair because we do. But what does that actually mean, right? So it means that your broker dealers are going to have to make some adjustments, most likely to the way in which you are compensated. And the examples that I pulled out from the preamble to the rule include the ones on this slide. So think about taking away the financial incentives to recommend one similar product over another and instead say, okay, well, this product is far more complex. This takes a lot more time to study, to discuss with the client. The recommendation is a little bit more involved. That type of differentiation is what they consider a neutral factor. So they're encouraging the BDs to sort of migrate in that direction. They also have encouraged the BDs to put in some new supervisory mechanisms so that if you hit a trigger, say, so you're in a rollover situation or you're recommending a very high cost type product, then the BDs might go in and just take a double look at that to make sure that it comports with their understanding of this best interest standard. All right, so Maggie, we can move to the next slide. This one, just to round out these 4 obligations, this obligation is clearly on the broker-dealers. Essentially, they need to come up with some kind of overall compliance program to make sure that their sort of army of representatives are satisfying the new regulations. So this is on the BDs. This is going to be internal policies and procedures. So something you might see here coming out of this obligation is something Judy and Gary and I have talked about a lot. And that is they might want to see more documentation from you, why you made a particular recommendation, what factors went into it, so on and so forth. Something like that could be seen in this type of compliance program. But again, wait and see what those broker dealers tell you. All right. On to Form CRS. So this is meant to be the very top layer of a layered disclosure regime. So this is the very, very, very basic information. When they proposed the Form CRS, they wanted 4 pages. Everybody went in and said, nobody's going to read a single additional paragraph. Everybody is drowning in paper already. So they did cut it back a little bit, 2 pages for non-dual registereds. And this is where you give a general description of the capacity in which you are acting. For us, that's broker-dealer registered representative primarily. The types of fees and costs. So this is when you can say, generally, I get compensated by receiving commissions. That is fine at this level of disclosure. You have to say that you have to work in the client's best interest, and you have to disclose legal or disciplinary actions against the firm. So this is a brand new standalone document. But they have encouraged this one applies, I should have said this from the outset, this one does apply to both investment advisors and broker-dealers and their representatives. So this is a new thing for everyone, but they've encouraged you to use graphs and charts and make this really consumer-friendly, readable, digestible by normal human clients, which is great. So the next one, we don't have to spend much time on at all. This is really, as I said at the outset, a restatement of current law and how the SEC will, going forward, interpret these solely incidental exemption for broker-dealers from the 40 Act. So these are the type of advice activities that you can engage in, so non-sales activities, and not be considered an investment advisor regulated under the investment advisors statute and regulations. So the great news is here, as long as you're still giving advice that is tied to, connected with your sales activity, then you're okay. Your primary business purpose cannot be to deliver the advice without the sales activity. That does clearly make you an investment advisor. And your advice does not have to be trivial, incidental, or infrequent. You can give all of the advice that you want, as long, again, as that connection is maintained between the advice and your actual sales activity. So overall, I think there's no surprise here. This is consistent with how the SEC has interpreted this exemption all along, but good to sort of see it consolidated, put in one place where we can all, see it a little bit more clearly. So that was a lot that I just threw at you. As Judy mentioned, this thing is like 1,200 pages long, and we managed to just get it down to 10 slides. So, there may be a few questions.
So I should throw in right here, Kate, too, that there are a lot of resources that are available and will continue to be available on the NAIFA website at naifa.org. We have resources including this webinar recording and the slide deck, the summary memo from Sept that is about 36 pages that breaks the rule down, but certainly in more detail than we've been able to do here. There will be frequently asked questions, Gov updates. As we get more information, we will continue to add that to the NAIFA website, the rule and those documents and the SEC's press release and so forth, also available on the website. So while it is a lot to take in, there are a lot of resources available to NAIFA members on at naifa.org.
Great. And now I think we're turning it over to Gary to discuss what is going on at the state level.
Thanks, Kate. Before I do, though, let me mention, I think first Judy and Kate gave some great background, and I think this has been a long, complicated road, to say the least, but I really think that filling in a lot of the details like Kate and Judy just did helps all of us to understand how we sort of ended up where we are. As Kate just said, this is a long, long rule. The rule, along with all the commentary, interpretation, discussion of the comments, goes to well over 1,200 pages. So the bottom line is that whatever we tell you here today is our best take of what this all means, but this is going to take a little bit of time for everything to shake out and to get some clearer interpretations, perhaps from the SEC itself, of what some of these provisions mean. So we all need to keep that in mind. What we're telling you today is our best sense as to what all this boils down to. Also, let me mention that with respect to the titling restrictions issues that Kate discussed, the ability to use the word advisor in describing yourself and all, we met, and this has been a process we've been going through for a number of years. We met with the majority of the SEC commissioners. We typically have a NAIFA leader, either the current president or a former president of NAIFA, as well as a number of our staff members, CEO Kevin Mayu and people from our GR team here, meet with the SEC commissioners. And we met with also a bunch of them, including Chairman Clayton. And on this issue specifically, we noted our concerns about the workability of the titling restrictions that were originally contained in the proposal. And we were very glad to see that a lot of our concerns were addressed in the final rule and did make things a little more tolerable and a little easier. So now, basically, let me turn to the state issues, basically. At the same time as the SEC was in the process of developing Reg BI, state legislators and regulators have also been taking a deep dive into these same state issues. Several states are at various stages of the process of putting in place their own enhanced standard of care requirements for broker-dealers, investment advisors, and in some cases, insurance producers. Basically, at the same time, on a sort of a parallel level, the NAIC, the National Association of Insurance Commissioners, which is basically the trade group for the 50 state insurance departments, is working to revise the NAIC's Annuity Suitability Model Regulation, which sets standard of conduct requirements for annuity sales, whether fixed or variable. So now let me give you a brief sort of overview of what the various states are up to. New York, for about the past year, was looking at revisions to Regulation 187. They recently put in place, I believe the effective date was August 1 of this year, revisions to that regulation, which put in place a best interest standard for annuity and life insurance recommendation and sales, notably not covering securities transactions, which became effective, as I said, on August 1st of 2019, and it'll be effective for life insurance recommendation and sales on February 1 of next year. While this has been called the best interest standard, and that's how the rule refers to it, NAIFA New York State and others in our space essentially equate it to a fiduciary duty and have real concerns with the restrictive nature of it. NAIFA New York State participated in a lawsuit challenging the validity of the regulation and authority of the New York Department of Financial Services to adopt the rule. Unfortunately, that lawsuit was dismissed by the court about a month ago, and NAIFA New York State will not be planning to appeal. Turning to Maryland, Senate Bill 786 in this year, 2019, would have required broker-dealers, investment advisors, and insurance agents to all be subject to a fiduciary duty. NAIFA Maryland formed and led a coalition that was successful in our efforts to kill this bill, but I think we'll be seeing it coming back again next year. Nevada is maybe the first state that has dealt with this issue. Back in 2017, the state of Nevada enacted Senate Bill 383. What that bill did was basically broaden the definition of who is a financial planner to include broker-dealers, investment advisors, and their representatives. Since under existing Nevada law, financial planners are already subject to a fiduciary duty as a result of the Senate Bill 383, now we have a situation where broker-dealers and investment advisors and their reps are also subject to that same fiduciary duty. Again, purely insurance activities and insurance agents are not included in the scope of that law. The law doesn't have many details in it, and it's been left to the state securities administrator in Nevada to propose and adopt implementing regulations, to sort of put the meat on the bones, if you will, of what that law provides. That process, I'll say, has been moving at a snail's pace. Draft regulations weren't published until about a year after they were supposed to be. NAIFA and others submitted comment letters back in March 2019, and there's been really no new activity or news since. Rumor has it that Nevada, or at least the securities regulator, is sort of looking for a way out of this, whatever that means, given that the law itself does impose the fiduciary duty. Two more states to talk about. In New Jersey, the New Jersey Bureau of Securities has issued a proposed regulation that would have put in place a formal fiduciary duty for broker-dealers, investment advisors, and their reps. NAIFA and NAIFA New Jersey submitted a comment letter back in June 2019. Dennis Cuccinelli from NAIFA New Jersey, and also a member of the NAIFA board, testified at a hearing on this proposal in July of 2019. There's been no further action or news since, but this regulator seems intent on moving forward, and it's going to take them some time to read all the comments that were submitted. Finally, Massachusetts, in June of 2019, this year, the Massachusetts Securities Division issued for preliminary comment a draft of a regulation that would apply a fiduciary conduct standard on broker-dealers, investment advisors, and their reps. The draft proposal is really similar to the New Jersey proposal, and what we've seen so far is not a formal proposed regulation. So the typical administrative requirements that we see in most states for a hearing, a certain comment period, have not applied yet. In late July, NAIFA Massachusetts, along with NAIFA and others, submitted comment letters to the Securities Division in Massachusetts, pointing out concerns with this proposal. Massachusetts Secretary of State, who supervises the Securities Division, has a strong reputation in consumer protection and is very likely to move forward on this issue. We were expecting a formal regulation to be proposed by the end of the summer, which would trigger then a comment period and a hearing requirement, but that hasn't happened yet. And finally, let's not forget the NAIC. For about 2 years now, the Organization for State Insurance Commissioners has been working on revisions to its Annuity Suitability Model regulation. This would basically replace the suitability standard of care with a best interest of the consumer standard of care. Like I said, this has been going on for quite some time. NAIFA has been heavily involved in this NAIC process from day one. We've testified at every meeting of the NAIC that discusses this. We've submitted numerous comment letters on this topic. And right now, the working group at the NAIC that's dealing with this issue is in the middle of a heavy series of 2-hour-long conference calls to discuss revisions to this model and try and finish something up. We've been having about a 2-hour conference call every week, and they're going to continue for the next several weeks. And I think the goal right now is to have this set of amendments finalized and ready for adoption at least by the Parent Life Insurance Committee at the next NAIC meeting, which is going to be held in December. So I think it's an understatement to say that this activity in the states is making things both more complicated and difficult from a compliance standpoint. First of all, regardless of what they're calling it, these state proposals would basically end up imposing a fiduciary duty on the activities of broker-dealers, their reps, and in some cases, insurance agents. The problem with this is that a common thread in all these proposals is that whether they do it explicitly or not, they favor and they push advisors towards a fee-based business model rather than a commission-based model. The bottom line here is that many small and mid-sized investors will have no way to turn to for advice and service down the road, since, as most of us know, I think, most fee-based advisors typically have minimum account requirements of $250,000, $500,000, or even more. So a lot of our members' clients are going to be basically shut out of access to professional advice and service. Second, there's a very good chance that these state proposals, if they end up being enacted, are going to have differing requirements from what Reg Bi requires. So who does the rep listen to? which laws or rules does she follow? This could really put our folks into an impossible situation. But honestly, so far, the state regulators and legislators we've commented to don't seem too concerned about this. And finally, there are all kinds of legal questions swirling about whether the states can even enact these laws in the first place, or whether federal law, meaning the security statutes and the SEC rules, cover or preempt the field here. These questions are also going to eventually have to be decided by the federal court. So now, what does all of this mean, we've said, here in the real world for our members who go out every day and meet and work with their clients? How does Reg BI impact them? We're going to spend a little bit of time now trying to answer some of these questions and do it again in the form of basically a Q&A. These are questions that we've developed. These are questions that we've already been asked by some of our members. So we're going to try to walk through all these and give you a better sense of what this means for you. But as I've said before, and we're going to keep repeating, please remember what I said way back at the beginning here. You need to always follow the instructions, the procedures, and the direction that you're going to get from your broker-dealer. Again, do what your BD tells you to do. So let's have a little bit of a free-for-all here. Let me start asking questions, and our panelists will give answers. First, starting at the beginning, I only have an insurance producer's license, no securities licenses, and I don't sell any securities. I only sell insurance policies and fixed or indexed annuities. So the question is, does Reg BI affect me? In what way? Do I have to provide clients with this new form CRS?
No. So Reg BI applies only to those who are licensed by the SEC to sell securities products. If you are not licensed by the SEC, lucky you, you don't have to worry about any of this.
Okay.
So as an add-on to that, though, there are a lot of folks, including some who are on the webinar, who are distressed. And one of their questions is, Gary, will the NAIC's efforts address the fact that someone recommending an indexed annuity is not subject to the disclosure requirements, the standards, and the obligations that someone selling a variable annuity, for instance, would be? That this is almost unfair in the marketplace, and is the NAIC's work addressing indexed annuities as well?
Bottom line here is that the NAIC work and the NAIC model addresses all annuities, variable, fixed, as well as indexed. And again, the bottom line is what the NAIC is working on does not set different standards for different types of annuities. Everybody who recommends or sells an annuity has to meet the same requirements under the NAIC model. Now, the NAIC model also contains, and this is something they're still working on the details of, a safe harbor provision that basically will provide, we think, that if a broker-dealer firm and their reps are already following the requirements of Reg BI, for example, they will be deemed to have satisfied the requirements of the NAIC model. But there aren't any, in the NAIC model, there are not separate standards of care, separate disclosure requirements, say, of increasing complexity, depending on whether you're selling a fixed, and indexed, or available annuity. It's all subject to the same thing.
Okay, thank you.
Yep. So following up on the first question, so if I have both an insurance producer's license and a securities license, does Reg BI apply to me when I'm recommending or selling purely an insurance product, such as a term or a whole life policy or a fixed annuity?
No, so regulation best interest is triggered when you make a recommendation of any securities transaction or an investment strategy involving securities. So if securities never come up in the conversation, you don't trigger this regime.
Great, thanks, Kate. And let me also remind folks, just going off on a little bit of a tangent here, that if someone is only insurance licensed and they're talking with a client about recommending a fixed annuity to them, if the conversation starts veering into where do I get the money to buy this product, and the insurance producer starts talking about, well, you could sell some of these mutual funds you owe, for example, that's not allowed, not only on the Reg BI, but on the current federal law, as well as on most state insurance laws as well. You can't give advice about a security, even if it's only about how to fund a pure life product. You can't include in the discussion securities unless you're also securities licensed. Moving on, which requirements of this, there's been a lot of talk here actually about what the BD, the broker-dealer's requirements are, responsibilities, what the rep's responsibilities are. So what requirements of this regulation directly apply to the registered reps of broker-dealers, requiring me to do or say or give something to my clients, and which requirements, even though they might affect me, really apply only to my BD and place the responsibilities and duties on the BD alone?
Right. So going back to the overall structure of regulation best interest, there are 4 buckets of obligations. The first 2, the disclosure obligation and the care obligation, apply directly to registered representatives as well as the broker-dealers. The second 2 buckets, that conflict of interest and compliance policy piece, that only applies directly to the broker-dealers, not to you as registered representatives.
Thanks, Kate. Okay, in addition to I have an insurance producer's license. I'm also a registered rep of a broker-dealer. Does Reg BI or any of these other rules Kate was talking about now require me to disclose to my clients how much I'm going to be compensated or paid for selling them stocks, mutual funds, variable annuities, other equities?
So there are comp-related disclosures that we went through during the slide presentation. So Form CRS has very, very high level, general, generic, non-client, non-product specific compensation disclosures, broad categories like commissions, trailers, what have you. Then the compensation disclosure obligation within the regulation best interest gets a level deeper than that. And it says, you have to, at this point, get a little bit more specific. So if you're talking to somebody about mutual funds, likely here your broker-dealer is going to have you disclose, okay, my typical percentage range or my typical amount range to sell this kind of product is XYZ. So yes, you are going to have to make some additional disclosures here, but it does not have to be a specific dollar amount for the person who's sitting in front of you.
Thanks, Kate. I think it was mentioned earlier, I think, in the conversation here that the term best interest is not defined. Best interest is obviously an important part of all this new regulatory regime. So other than going by the standard of I know it when I see it, how's it going to be measured whether I've acted in the best interest of my clients?
So again, this is going to be based on you fulfilling the obligations under Regulation BI that apply to you. So in registered representatives cases, that's the disclosure obligation and the care obligation. To satisfy the best interest standard, you need to be in compliance with both of those obligations. For the BDs, they need to be in compliance with all 4 of the obligations to satisfy the best interest standard.
Great, thanks. Okay, so I'm getting a better sense of what this rule requires of me, what it means in the bigger picture. But one question I have is, if I have to act in the best interest of my client, does that mean that I'm now allowed to only recommend to my clients the single best product for them? For example, if it's a fixed annuity, I'm required to recommend the best fixed annuity to the client. And if the answer to that is yes, how am I supposed to determine what is the single best fixed annuity? And who's going to decide whether I've made the right decision? How are they going to decide whether what I've recommended is the single best annuity?
So the good news is you do not have to recommend the best capital T, capital B product to a given client. That said, whatever recommendation you do give has to be in the best interest of your client. So if you feel that among the suite of products you do offer, whether that's limited by proprietary product restrictions, limited based on your type of license and what you're allowed to sell, if you're looking at all the options in front of you, the one that you recommend to your client, you have to satisfy that care obligation and the disclosure obligation. And in terms of, a little bit of discussion came up in the preamble to Reg BI about, okay, well, there's a lot of products out there, a lot of products that I never sell because I only have relationships with one BD, or I only have access to certain products, right? And they basically said, you don't have to know about all the products that are out there. You have to know about the products that you sell. And it's okay for that to be not the entire universe of all securities products. But again, within what you do sell, if you're looking at it and you're like, honestly, client Judy, of the things I can sell you, nothing fits, nothing is in your best interest, then they would expect you not to actually make a recommendation in that instance.
Yeah, and if I could tag on a little bit, in the question that Gary asked, it was about the single best fixed annuity. Well, of course, fixed annuities aren't subject to the rule at all. So
trick question, Gary.
To be clear again, This is only for securities products.
Judy gets some bonus points.
But some of the follow-up to Kate's answer is just common sense and best practices. You should be documenting how you're coming about the recommendations that you're making. You should be keeping good records, as should your staff, by the way, of the kinds of information that you're asking to get the client to say, these are my objectives, these are my goals, this is my situation. If you have all of that in place and then you make a recommendation that is in the client's best interest, you will have done a lot to go towards being able to evidence that even with perhaps a limited number of products, it does in fact accomplish the client's objectives. So documenting, fact-finding, keeping your staff aware of what all these requirements are certainly things that NAIFA recommends that are common sense, and I'm sure what you're already doing.
Great. Okay, I got a better idea now of what it means to act in the best interest in that regard, but similar question, do I now have to recommend the products that are going to pay me the least or going to be the least costly to my clients?
So no, you do not have to recommend the least expensive product to the client. But here is a little change from the suitability regime. So you must now, under the best interest framework, take cost into consideration when making a recommendation and deciding whether it's in the client's best interest. It has to be a factor. It is not the determinative factor, and the SEC goes out of its way in the preamble to the rule to explain that, understanding that the cheapest option is not always the option that fulfills the client's objectives, to Judy's point, based on that individual client's investment profile. But again, I think this is probably where the documentation comes in. If you are recommending a product that is a lot more expensive than some of the other options, particularly if you're talking about kind of comparable options, then I anticipate that this is the type of spot where you're going to want to be documenting everything to support your recommendation.
So one of the follow-up questions that we have from our audience to that, Kate, is does this regulation BI replace suitability standards?
No, this is a great question, and I actually, in the interest of saving time, skipped right over that at the beginning. This doesn't replace anything. So all of the rules and regulations that are on the books with the SEC before June 30th, 2020, when this thing goes into effect, stay in effect. So this is meant to be layered on top of everything that already exists.
Okay, great. Now we've had a lot of discussion, and I'm sure a lot of you have questions about basically being able to use the words advisor or advisor. We have a whole series of questions we've been asked about this, and I think we're going to run through these like that old game show did when they had a lightning round. So I'm going to ask some questions, we're going to get some answers, I'll go on to the next one. First, if I'm just licensed as an insurance producer, do these restrictions on titling apply to me?
Nope, same thing as Reg Bi. If you're not dealing in securities products, they do not apply to you.
I'm a registered rep, but I'm not an investment advisor rep. Can I write on my business card below my name, advisor or financial advisor?
No, it cannot be those words. If you are not licensed as an investment advisor or an investment advisor representative, you cannot use advisor in your title or your name.
Okay, I'm a registered rep, but I'm not an investment advisor rep. Can I write on my business card below my name, member of the National Association of Insurance and Financial Advisors?
Yes, because that's not a part of your title or name.
Great. I'm a registered rep, but I'm not an investment advisor rep. If my company's name has the word advisor in it, can my company name be on my business card?
Yes, so the company name, it applies to the companies as well. So if the company is dual licensed as a broker-dealer and an investment advisor, they can continue to use their name and you can continue to use it on your business card because you're not claiming that word for yourself in your own name or title. However, if that firm is not a dual registered, they have to change their name. So that's going to be kind of driven at that firm level.
Gotcha. So now this gets more complicated. If my company has the word advisor in its name and it's only a broker dealer, but not also an investment advisor, does this mean that my company has to change its name or that I can't use my company's name on my business card?
Yeah, so the company has to change its name and it'll come off of everything. All of their marketing materials, everything they send to you would have to be changed.
Okay. Now, I'm a registered rep, but I'm not an investment advisor rep. In the various marketing materials I use, such as brochures, newsletters, can I say things like I've been a trusted financial advisor for 22 years? Or how about I've been advising my clients on their insurance and investment needs for 22 years?
Yeah, so the rule does allow the use of advisor by registered reps as descriptors in marketing materials. So exactly the examples that Gary just used would be okay, but be mindful, just as a general rule, whenever you're marketing yourself, advertising, that going back to that tricky little incidental advice exemption we talked about briefly, the primary purpose of your business cannot be giving advice. It has to be the sales activity. So even though the titling restriction isn't a problem here, be mindful of how you're describing your business in general to the public.
Gotcha. Now, I'm a registered rep, and I'm also an investment advisor's rep. Can I write on my business card below my name advisor or financial advisor?
Yep, if you have that investment advisor license, you are good to go.
Okay, I'm a registered rep and an investment advisor rep. Can I write on my business card below my name member of the National Association of Insurance and Financial Advisors?
Yes, you can.
I'm a registered rep and an investment advisor's rep. If my company name has the word advisor in it, can my company's name be on my business card as long as they are also an investment advisor firm?
Yes.
Okay, one last question here. I'm a registered rep and an IAR. In the marketing materials I use, can I say things like I've been a trusted financial advisor for 22 years?
Yep.
Great, okay. Moving on. I am only allowed to recommend the proprietary securities products of my broker-dealer, or my broker-dealer only has agreements to market these securities products of a limited number of companies. Do these new rules allow me to recommend these products? Again, am I acting in the best interest of my client if I can only recommend a specific basket of products?
Yes, so just like preserving variable compensation arrangements like commissions, this is another area where the SEC is very clear. They are not trying to restrict you from selling only proprietary products. That said, this was clearly flagged in a lot of the comments that they received as a conflict of interest or an arrangement that could potentially create conflicts of interest between financial professionals and their clients. So throughout the rule, you'll notice that the SEC has really pulled out this proprietary product issue. And anytime you have to describe the nature of your business, the nature of your services, material conflicts of interest, this is one of those things that you're going to have to talk about with your clients and put in these new disclosure materials.
Gotcha. Once I've made a recommendation about a product, do I have any kind of ongoing responsibilities or obligations to my client about that product? For example, to monitor it, reach out to my client every few months?
So no, there is no automatic ongoing obligation here. The regulation best interest is actually designed to be a transactional standard of conduct, but you do have the option of taking on that obligation. If you're going to do that, it needs to be laid out very clearly at the beginning of the relationship in your best interest disclosure obligation, so your new disclosure materials. Again, though, if you're going to take on that ongoing monitoring activity and that obligation, I would just double check the new guidance on the solely incidental exemption, because they have a special discussion in there about when monitoring can actually kind of seep over into that investment advisor space. So if you're going to take on that obligation, I recommend doing your homework and making sure that you're not accidentally subjecting yourself to the Advisors Act.
Yeah, and they can always refer to their own broker-dealers and compliance officers for guidance on that.
Great. Following up on the discussion earlier, that was about compensation, I guess, or models of compensation. Are there any compensation models or types of compensation models that are barred completely? What about sales contests?
Yeah, no, sales contests are gone. Those have to be eliminated. Quotas, bonuses, anything based on sales of specific products within a limited time frame.
Great. One more question here. Does the new best interest standard require me to recommend the product that is the least expensive for my clients?
No. So again, you have to take cost into account. That is a new feature that was not written into suitability, but is under regulation best interest. It does not have to be the only factor. It does not have to be the deciding factor, but you're going to have to, again, to the extent you're documenting how and why you're making these recommendations, this is something that you're going to want to actually pay specific attention to.
Thanks, Kate. Let me turn things over to Judy now to talk for a very quick minute or so about the types of resources that are available for NAIFA.
Yeah, as we're wrapping up here, and thank you again all for joining us, there are a lot of resources on the NAIFA website, as we've mentioned. Maggie has just sent Gary's email and my email. If you have a specific question that you want to ask us afterwards, we're resources too. And then, by the way, you are resources. By the time Gary was done scaring us with what's happening at the state level in so many places on so many issues, what NAIFA brings is this incredibly powerful and influential grassroots. And I would encourage you, when you see something, if it's state specific or at the federal level, that says, please reach out to your lawmakers, please do. If you have any questions about it, we're always available to answer any questions and to help or give you more background. But with all that's going on, NAIFA is by far the largest, is the oldest, and is the most influential. And your help and getting others of your colleagues to join NAIFA so that we can expand and develop depth in that grassroots program is part of how we can be influential in a good way in protecting businesses of NAIFA members.
Great, thank you. We're just about at the end of our time. We've just about an hour. We worked it really well with the timing, I think. But let me just close by first thanking everybody for taking the time to listen in. Hope you found this helpful. And also remind everybody to remember the Reg Bi Golden Rule, which is follow your broker-dealer's instructions and procedures. And it's your responsibility to know and understand what those are. Thanks again, everybody. And like was said, this webinar and the PowerPoint will be available on the NAIFA website. And you can contact Judy and I for any questions you have, and we'll do our best to try to answer them. Thanks again, everybody.